So briefly going up, we had 101.6 acts, other acts done in preparation for or planning terrorist acts. 2. Sections 101.5 and 101.6 of the Criminal Code titled Collecting or Making Documents Likely to Facilitate Terrorist Acts and Other Acts Done in Preparation for or Planning Terrorist Acts were said by the plaintiff to be relevant to the potential future acts of the defendant and comprise illustrations of serious terrorism offences which the defendant poses an unacceptable risk of committing. And what we've come to learn is that there were no acts to facilitate a terrorist act. There was no preparation or planning for a terrorist act. Matthew Reason had it in his own mind that something was illegitimate and decided to act upon it, and in the acting upon it committed war crimes against that war memorial, which was in attendance by those in remembrance of their fathers, and then went about committing a heinous war crime by dragging US through a court system based around these terrorism offences, which then led to the drugging of a civilian within the auspices of corrective services, going against Rule 92 of international humanitarian law, furthering this criminal action. Matthew Reason is the cause and trigger to all of it. Matthew Reason, in his own words, admits to taking command. And as we keep going back, section 100.1 of the Criminal Code, which defines a terrorist act. And then 9, the state says, for the purposes of 20C of the Act, the defendant is a convicted New South Wales terrorism activity offender, as defined in section 10 of the Act, relevantly as follows. So at section 9, Matthew Reason and the state, especially the prosecution team for the state, Crown Law New South Wales, have told the court that he is a convicted New South Wales terrorism activity offender, even though no terrorism activity was involved in his sentencing. How can he be a convicted New South Wales terrorism activity offender without the conviction? Owning a pistol that is a gel blaster that has the incapability of harming anybody does not end up becoming a convicted terrorism activity. The prosecution have lied to the court from the very get-go. They have brought out their tarred brush from the start by using the term convicted New South Wales terrorism activity offender, at which the justice then defines what a convicted New South Wales terrorism activity offender is, and then undoes that very succinctly in the case that follows. So it's very clear here when we get to 9 that the Crown Law Office of New South Wales has immediately jumped to the conclusion that immediately tarred the defender in the wording they've used in the application. 8. Section 6 defines the word serving a sentence of imprisonment. 7. Section 6 and 7 deal with the persons to whom the Act can apply. Section 7 defines an eligible offender as. Now, this is a good time to bring up the class separation that the Justice alluded to previously. What is a ward of the state? Why do these patricians treat you like plebs or plebiscites? Why do they treat you like cattle? And there is a very clear answer in it, in that you are being treated as if you are wards of the state. So we get to the top of the legislation and we see that the requirements for setting this extended supervision order are set out in this act that is determined up above. We can see that throughout the legislation, the Justice has defined very specific terminology that is being used by the police to demonstrate to the police that they have failed in their ability to define the defendant as such. It's very clear that at 9, at the very beginning of the matters, the police, the state and the Crown Law Office have all tarred the defendant with a terrorist brush without even having committed any terrorist offences or attempted to undermine the Constitution in any way, shape or form. It can be demonstrated very clearly that through his actions he sought to defend the Constitution. We can see then we end up at slide 1, back at the start of the case, where the decision is dismissed and the state is to pay all costs. So coming back up to the top, State of New South Wales versus Kiskonan. When you look at the State of New South Wales very clearly, you can see that the Justice works for the Supreme Court of New South Wales. You can see that the Crown Solicitor's Office is the Crown Solicitor's Office of New South Wales. When you look at the police, you can see that they are the New South Wales Police Force. When you look at the underlying oath of allegiance that befalls all of them, it defines a line of authority in which they stand. They're all on the same team, and this Justice has done a very, very fair job of dealing with a very, very technical matter that the police are attempting to smear now, in the fear that the truth or reality in the matter might come back to bite them in the arse later. Rule 92 and Rule 90 of international humanitarian law would surely demonstrate that bite to be a big one.